in appeal of the estate of Claudia Edwards Bethel against the Attorney General of the Bahamas and another.
Yes, Mr. Mr. Bench.
Yes, good morning, my lords and my lady. I appear on behalf of the appellants this morning, broadly speaking, the state. With me is Kayla Greensmith, Deputy Director of Legal Affairs, Nevado Fraser, counsel from the same department. For the respondent estate, Mr Fred Smith, King's Counsel, is leading the charge, as it were, ably assisted by Ruth Jordan, Roderick Dawson, Malone, Doneth, Cartwright, Suzanne, Ter, Minassian. Sorry if I haven't pronounced that correctly, but that's the team, as it were. May I just make some introductory remarks, if I may, about the appeal and the issues today. There are two broad issues before the board: the arrest and initial detention point and the vicarious liability point. I'm going to reverse the order of my submissions, if I may, and deal with the vicarious liability point first, because it seems to me that is the thornier point, perhaps, in terms of the legal issues, and certainly it's the one that we want to say most about. So I'll deal with vicarious liability first and then deal with the remainder. I just want to make one or two comments, if I may, about the context of this appeal and why it matters for the state. And in doing so, also make plain that we accept, of course, this is a very sad case. What happened to Mrs Bethel was appalling, and nothing we say today in any way seeks to detract or minimise that. I appreciate that point is obvious, and this is a court of law, not morals, but it's something I wanted to just make clear at the outset. I should say, obviously, the state has fully accepted the factual findings against Mr Bastian. It has accepted the factual findings against, or in respect of, the state, the conduct of the police, being turned over to immigration, the role and supervision of Mr Bastian, and his accepted authority, at least, to take Mrs Bethel out of the detention centre for the purposes of verifying her address. We also accept, of course, that in respect of the initial period of arrest and detention, that once the position in respect of her immigration permit was resolved at the station, she should have been released, and that she was unlawfully detained during the remainder of police custody and at the detention centre. And we've accepted vicarious liability for all of those, or direct liability, in effect, for all of those periods. So the only 2 points that the state does respectfully take issue with are the extreme and unusual and unpredictable actions of Mr Bastian in detaining and raping Mrs Bethel at his house, and the initial arrest and detention following a fractious and difficult dawn raid of the bar on the 14th of December. And in both of those respects, we are seeking to restore the decision of the High Court. In respect to vicarious liability, still just on introductory points, we accept, of course, that it is not fault-based. But my lords and my lady will appreciate it's not always reported in that way. And the state does have a vested reputational interest as an employer and as a state to ensure that the proper confines of the doctrine of vicarious liability are adhered to. It does also, we submit, have fault implications because of the nature of the close connection test and the fact that risks created by an employer is part of, or can be part of, the close connection test, because of course if an employer creates risks those risks themselves may be factors that go towards establishing a close connection. And that's important in this case. But it also does give rise to considerations of safeguards, rules, protocols and protective measures to put in place. And I make what I hope is an uncontroversial statement, but an important one in this case, which is that the more safeguards that are put in place, or the more permissions that have to be breached or rules broken by the tortfeasor, those breaches should count in the close connection test away from a close connection. In other words, the more hurdles a tortfeasor has to jump, the more protocols they have to breach in order to commit their tort, it stands to reason, logically, we say, that those are factors that would tend, other things being equal, to point away, to detract from the close connection. So there is a sense in which an employer, the more hurdles they put in place, the more protocols they put in place, can to some extent protect themselves from a vicarious liability. So it's not unrelated, although it's not fault-based, it's not unrelated to sorts of considerations that one might look at in the duty of care type case. And I have in mind, for example, the BVI case, which is the Hartwell case, where one of the factors relied upon by this board in finding that there was no vicarious liability was that the police revolver, was taken from the police station against the rules, without the superior officer's permission. That's the sort of thing one has in mind. There was obviously a protocol in place in this case, certainly in respect of having a female officer present during all interviews with a female detainee, and only releasing a female detainee to go to verify her address if she was accompanied by a female officer. And that protocol was breached in this case, which is one factor that the judge placed reliance on. And the Court of Appeal, in our submission, effectively ignored. I'll come to that in more detail. In respect of the lawful arrest point, we say this is effectively all about context. It's a reasonable suspicion that Mrs Bethel did not have immigration status in the context of a difficult dawn raid and a group arrest. The judge accepted Superintendent Curry's evidence given over 3 days. He was cross-examined for 3 days, almost solely on that point. I appreciate you put in a very short statement, but he gave 3 days' worth of evidence. And she found as a fact that the reason for the arrest was immigration status, and that there was a reasonable suspicion in that regard, and that the inability to verify her status made it reasonably necessary to effect an arrest. And we say there's nothing wrong with those findings.
But you're going to come back to that?
I'm going to come back to that, but I'm just giving a brief sort of introductory overview. I'm now going to start the submissions proper on vicarious liability.
Can I just clear one thing out of the way before,
Yes.
before you do that? You referred to the appellants as the state. For the purposes of this appeal, they all stand together because obviously in relation to vicarious liability, the Commissioner of Police might be in a very different position from the others, but we don't need to trouble about that. Yes, the particular department that would be responsible for Mr Bastian's conduct would be the immigration department, and the minister responsible for that. But for the purposes of this appeal, I didn't think it was worth Thank you.
It'll come out of the same kitty if they have to pay. That's true. Sure. What is so two preliminary points on vicarious liability, in addition probably to the one I've already made. The first preliminary point is just to consider what is the nature of a determination of vicarious liability. Appreciate it may be a simple point. It's plainly a question of mixed fact and law. I mean, I don't think there can be any debate about that. The facts are obviously for the trial judge, and the judge, having found the facts, must then apply those facts and any inferences to be drawn from those facts to the legal test. But we do submit, although I haven't found any direct authority on this, I just submit it as a matter of principle, that this is one of those legal tests that requires a high degree of evaluative judgment to be undertaken by the trial judge, who is immersed in the facts. Days and days and days of cross-examination of the witnesses in this case. And the appropriate stance of an appellate court would be that which would normally apply to mixed questions of fact and law that involve very fact-sensitive and evaluative judgments to be made, which is, to put it succinctly, the judge has to have done something wrong. The question must be really whether the finding or rejection of vicarious liability was one that was open to the judge on the evidence led before her. I would just give the reference to the case, the Clinton-Bernard case, which is the Jamaican case, the police shooting. Paragraphs 1, 2 and 28. We can turn it up if we need to, but just...
We have a page number.
Sorry, so the decision starts at 2977.
Thank you.
Perhaps I will just go to it, actually.
I wasn't asking you to, but just so I got it in my note.
So 2977.
This is a case about the policeman who wouldn't wait for his turn to use the phone.
Yes, that's right.
Yeah.
And I'll come to a moment, because the degree of caution is required about the police cases, because, of course, they're in the unique position of being able to bring themselves on duty. So it's an unusual factor when one is assessing the scope of the authorised act. I'll come to that in a moment. But yes, that is indeed, he says, I want to use the phone, and the guy says no, so he shoots him. I mean, that's a horrible reduction of the facts, but that's basically what happened. And all I really say is that the board's judgment in that case delivered by Lord Steyne opens with the proposition that the central issue in this case is whether it was open to Mrs Justice Michaela, the trial judge, on the evidence placed before her to find the Attorney General of Jamaica vicariously liable. And a similar thing is said in paragraph 28. These factors have persuaded the board that the trial judge was entitled to find vicarious liability established, and that the Court of Appeal erred in allowing the appeal. So I'm just, I mean, there's only so much one can read into some, two or three words in a judgment, but that does seem, with respect, to be the correct approach to a vicarious liability finding. I think, I submit rather, sorry, that what may have happened in these sorts of cases is that, of course, there has been a lot of appeals because the principles have been somewhat uncertain for a significant period of time until a series of judgments from the court next door. And therefore, perhaps appeal judges have been more willing to entertain appeals, and in some cases almost appear to be deciding the questions de novo. But our submission is that now the principles are crystal clear, it's appropriate to return to the status quo that applies to any other judgment made on a mixed question of fact and law, as opposed to simply doing what the Court of Appeal did in this case, which is effectively just dive in and give its own opinion. Second preliminary point concerns the child abuse cases. One gets a flavour from the respondent's case in parts that there's an attempt to sort of cross-apply the rationale from those cases to this. We would obviously resist that. The vicarious liability is established in the institutional child abuse cases for the obvious, what seems obvious now, it didn't seem obvious at the time, but what seems obvious now, that the unusual degree of control and authority and responsibility given to carers and teachers of institutions that care for children, with the awesome responsibility that entails. And looking back, perhaps, I think there's some terminological difficulties because of the salmon test, but once one puts that out of the way, looking back, it seems almost axiomatic now in those sorts of cases that there would be vicarious liability just because the employer has delegated such an awesome task to the employee. But it's that factual context, obviously, that establishes vicarious liability in those cases, not the fact that it involves sexual abuse. I mean, I appreciate that's an obvious point, but it's the I just wanted to outline that. The law on vicarious liability, I hope I can be forgiven for taking that quite quickly, given where I am. But what I would like to do is just to pick up some of the themes that we develop in our written case, just to emphasise one or two principles that we think are particularly important to the facts of this case. So can we please pick up, if I may, at paragraph 43 of my case, which is at page 2798, tab 4 of the core bundle. This case only concerns stage 2. There's no suggestion below that Mr Bastian was a Crown appointee like a police officer, accepted that he was an employee, rightly or wrongly. So we're looking at stage 2. It's concerned with the link between the commission of the tort and the relationship of employment. The question, of course, is whether the wrongful conduct was so closely connected with the acts that the tortfeasor was authorised to do that it can fairly improperly be regarded as done by him whilst acting in the course of his or her employment. We just emphasise what I hope is a correct understanding of the test, which is that the close connection test is the analytical framework through which the court is to assist the court at answering the big question. The big question is, broadly speaking, was the wrongful conduct, was the tort something that was done in the course of employment? That's still the question. It's still the question. And it's the overarching question. But the close connection test, as I understand it, is the framework that a court uses to help it answer that big question. And that's important for reasons that I will come to. but it reflects the case law talking about tasks that are reasonably incidental to the employment. I think an example is given in Lister of somebody that works at a factory, then pops outside to have a cigarette and throws the cigarette away. Not employed to smoke cigarettes, but it's something that's reasonably incidental to the tasks that he is authorised to do, and therefore, broadly speaking, in throwing away the cigarette, he's acting in the course of employment. I mean, that's how I understand basically the test works. On page 2800 of the electronic bundle, there's discussion of the policy. And about 7 lines down, at root, the core idea appears to be where the employer is taking the benefit of the activities carried on by a person. He or she should bear the cost, or one might say bear the risk of the wrong committed by that person. But the risk...
Does that cover the whole ground? I mean, taking the benefit may be one example of a sufficiently close connection, but there may be others where the relationship isn't taking the benefit one at all. It's just discharging an obligation.
Yes.
And I'm not sure taking the benefit had much to do with the analysis in the Jehovah's Witnesses case.
No, I should say at this stage, the Supreme Court was just reflecting on the policy justifications.
Yes.
And I think there were 5 given by Lord Phillips, and then in the earlier case, and then they were discussed as to how many of those and what weight should be accorded to those policies in the later authorities. But risk is one thing, though, my lord, that we say it's not just a policy consideration. It is also, as I think my lord is indicating, to be part of the close connection test. And I've been through that already. I've said why we say if an employer does things to ameliorate the risk, that breach of those protections is something that has to go into the mix. That case, we respectfully submit, is a good example of the important distinction between opportunity, circumstance and background factors, as opposed to factors that actually connect the employment role and the tort. So in our case at paragraph 52, we set out there what the courts below effectively held to be the factors sufficiently connecting the tort and the employment. And this is the Barry case concerned, of course, the rape by Mrs B, the rape of Mrs B by Mark Sewell, who was an elder of the Jehovah's Witnesses, but it was something done in a private household after any Jehovah's Witness activities had ceased earlier in the day. And one can see there that some of these factors are very sort of general in nature. Mark Sewell's position as a ministerial servant was an important reason why Mr. and Mrs. B started to associate with Mark Sewell. Well, that's context and background. But what it isn't is a connecting factor between the tasks assigned to Mr. Sewell as an elder of the Jehovah's Witnesses organisation. And again, the but-for point at B. And I won't go through all of them. I mean, they're there. The board will be familiar with the judgment. But one can look, for example, at the last one, E, on the next page. One of the reasons for the rape was Mark Sewell's belief that an act of adultery was necessary to provide scriptural grounds for him to divorce Mary, who's his wife. And of course, one pauses there to say, well, that's all very interesting, but what's that got to do with the authorised acts that Mr. Sewell was tasked with by the Jehovah's Witness organisation? So we plead this judgment in aid, obviously, for the clear principle that the close connection test requires, we say, a disciplined and targeted assessment of the evidence to identify factors that truly do link the tort with the tasks that are assigned to the employee, not just general background stuff. The next principle that we would like to emphasise is the distinction between authorised and unauthorised acts. And we say that that distinction is neatly demonstrated by the Morrison case, 2020 Supreme Court case, and I'm now at paragraph 60 of our case. Just want to focus on the extract from the judgment of the first instance judge that's copied out in paragraph 60 of the case. Just ask the board to read that. And one can see in my respectful submission where the difficulties arose in that case. Because, first of all, what appears to have been in the mind there of the judge was a connection between the position in which Mr. Skelton was employed. Now, I appreciate that is sometimes used as shorthand in some of the cases, but it's not the position as such that matters, but the authorised tasks, the authorised acts, the things he was told to do as part of his job that matter. And that's important because otherwise the close connection test becomes skewed if one just starts to think about status rather than authorised acts. And the second problem with it, which may flow from the first, is the suggestion that he was put into the position of handling and disclosing the data, open brackets, albeit it was meant to be to KPMG alone and not to the world. So this is a case where Mr. Skelton, charged with the responsibility of collating and passing to the auditors personal data of the employees, passes it to KPMG, but then also publishes it or tries to publish it on a website with newspapers and so on. And the difficulty there, respectfully, is that there's a running together, or let me put it another way, there's an insufficiently precise statement of his job. He was put into the position of handling and disclosing the data. Well, yes, but the point that Lord Reid was at pains to point out, which we extract in paragraph 64 of the case, is the disclosure of the data on the internet did not form part of his functions or field of activities, as it was put by Lord Toulson in the Mohammed case, in the sense in which those words were used by Lord Toulson. It was not an act in which he was authorised to do. And then further on the same page, whether Skelton's disclosure of the data was so closely connected with acts he was authorised to do, for purposes of the liability, his wrongful disclosure may fairly be regarded as done by him whilst acting in the ordinary course of employment. So in other words, the point of principle that we take from this is it's necessary, we say, when applying the close connection test, to have real clarity and as much precision as the facts allow, and I accept that won't always be possible, but there must be a sufficient degree of precision in identifying what are the authorised acts Because if you don't do that, you end up in a situation where you say, oh, well, his authorised acts were to deal with the data. And he did that in a bad way because he put it on the internet rather than giving it to the auditors. And that's how you arrive at, we say, an unprincipled decision. Well, I don't know, that may not be controversial, but it took me a while to get my head around it. But what we say is essentially this. The overarching question of the scope or course of employment is a broad one. So whether or not, the big question, as it were, the overarching question, whether or not the tort was done in the course of employment, one takes a broad approach to course of employment. And that's clear from the early authority, it's clear from Dubai, Aluminium and Lister. It's a broad approach to the question of course of employment. Because one is including within that torts that are closely connected to the authorised acts of the employee.
Something as wrongful as sexual abuse can never be authorised, obviously.
Exactly.
But there are still cases where
Absolutely.
that's connected with the course of employment.
Exactly.
And the children cases, the obvious example.
So you take a broad approach to course of employment, so broad that in some cases it indeed can include sexual assault of minors and so on. You're taking a broad approach to the overarching question. But in order to get to the overarching question, we say you have to take a narrow approach. You have to certainly take a targeted and precise as you can on the facts approach to the authorised acts question, because otherwise you end up with a skewed outcome. So in other words, let's take, for example, the Hartwell case, where the officer takes the revolver, he abandons his post in the main island in the BVI. He takes the revolver from the station when he's been told that he should not be taking it out, because he was caught earlier on a previous occasion taking it out, and he was told, well, don't take it out unless you really need it. He takes the revolver in breach of that direction, heads on to a different island, and then we know he goes to the bar and commits the shooting, commits the tort. The authorised acts have to be accurately defined, narrowly defined, because otherwise you could say, well, he was authorised to access a gun. He was trained how to use a gun. It was a police revolver. He had access to a gun, and therefore he went off and used the gun in an unauthorised way. We say, no, that's not how it works, because the board in that case was at pains to point out that one of the things that militated against a finding of vicarious liability was the fact that the gun was taken without permission.
The analogy with the cases to do with children might be seen in the fact that the teacher or the priest or whatever it happens to be is somebody who is placed by the employer or quasi-employer in a position of authority, and the authority that he has over children enables him to exercise a degree of control over them, and hence to abuse them.
Yes.
And there might be said to be an analogy in the present case.
With this case? Yes, well, I would accept, and the judge accepted, that Mr Bastian's abuse of his position as an immigration officer was one of the reasons why she stayed with him. The judge's finding on unlawful detention, that is to say that Mrs Bethel was unlawfully detained by Mr Bastian at his home, was because, first of all, Mrs Bethel was afraid of Mr Bastian personally, but also that she was afraid because she had a precarious immigration status and he wielded all this great power. Mm. And that's
but also that he was expressly authorised to take her into his custody.
Yes.
Which presumably involves an obligation either to return her
Yes.
to the
Yes.
the detention centre, or to release her.
Yes.
But until he did either of those, she was still in his custody.
Well, but in what I think the question, my lord, is in what capacity? I mean, we would
Yes.
say that the authorised act, we'll come to this in a moment, but we would say that the authorised act was to take her to verify her address. And the judge found as a fact that that act, that duty having been performed, there was no further immigration duties being performed. I mean, that was the extent of his actual authority.
What about taking her to the Immigration Department office where he interviewed her?
Well, I'll come to the judge's findings of fact. A bit unclear whether the judge includes that or not, but to be honest, whether she does or not, once those duties are exhausted, his authorised acts come to an end.
Well, but the duty continues to either return after the visit to her house or the verification of her status. The duty continues either to look after her until either he returns her to the immigration centre or releases her, isn't it? That's his obligation. You can't just say, well, I've done that bit, now I'm free.
Well, I don't think the judge dealt with it in terms of duties of care, but plainly, yes, he should have, once he'd exhausted his immigration duties, have returned her, and he didn't. But from that point onwards, that he is therefore embarking upon a personal...
Well, you say personal, but I mean, rightly or wrongly, he seems to have regarded himself as still investigating immigration status.
Well, I think...
I mean, otherwise, what are we to make of his taking her to the immigration office and carrying out an interview?
Well, even if one includes those facts in the mix, well, once that's done, that's it. I mean, he certainly doesn't have any duties after that to take her to various different, establishments, back to his house for food and all the rest of it. At that point, he's plainly detaining her in his personal capacity. And the point there is that we say that the close connection test can only really coherently work, we say, if you properly and with some discipline determine the authorised acts first, and then all the other facts, including the tort. So the tort and all facts and circumstances leading up to the tort on the other side, and you see whether any of those factors pull in favour or against a close connection. But the authorised acts should be sacrosanct, because if you bundle into the authorised acts stuff that isn't authorised, or you too loosely define the authorised acts, the whole test is skewed, as I say.
So a school teacher who took a child at, say, a weekly boarder out of school on the Friday and kept them on the Saturday and committed sexual abuse then would not be liable, whereas the school teacher who committed it during the week would. Is that where it leads us to? No,
it just depends on the facts. All I'm saying is one has to define the unauthorised act. So in both of those fact scenarios, one would have to look at precisely what the teacher was authorised to do. And then that's one side of the balance. And then on the other side of the balance, you put all of the other factors, the tort and all the facts and circumstances leading up to the tort, and you assess whether those factors... So Hartwell, again, he's authorised to act as a police officer to use the gun in certain situations, but not in the situation as he did. You carefully ascertain those authorised acts, and then you list out all the other facts, including that lead up to, that precede the tort itself, including any breaches of permissions and things like that. And then you work out on a fact-sensitive basis whether there are sufficient connecting factors for there to be, in a broad sense, a finding that the tort was done within the course of employment.
I mean, there's perhaps a parallel also with the Bernard case. I mean, if you think about the facts of that case, they're absolutely extraordinary. Where the policeman wants to use a public phone, somebody else is using it. He tells them to give him the phone. The person won't. So he shoots him in the head at point-blank range. So miraculously, the person isn't killed. He's taken to hospital. So what does the policeman do? When the man wakes up in hospital, the policeman is there and he arrests him for obstructing a police officer in execution of his duty. So the policeman thinks that he has been acting as a policeman throughout. I mean, plainly, he hasn't been. He's been acting quite wrongly. But he thinks, I've been performing my duties as a policeman. And in our case, we have this immigration officer who takes the woman to the immigration office. I mean, he continues to exercise control over her, takes her to his office, interviews her. The next morning, he tells the authorities that he is planning to continue his investigations, but he's frustrated by the fact that she reports him first for having raped her. So, I mean, it's not a charade. I mean, he thinks he's acting as an immigration officer.
My lord, I don't think I would accept that he thinks he's acting as an immigration officer.
Not when he rapes her, obviously.
Or that he detains her overnight, or that he tries to supply her with wine, or that he buys her food from the Chinese takeaway, or that he lies to the officers the next day at the police station by saying she's under arrest when she plainly isn't under arrest. I mean, and when he deceives his senior officer to sneak her out without a chaperone, I don't think I would accept, my lord, the plain evidence before the judge was that the whole thing was a stitch. I mean, there's no way this guy thinks he's operating on immigration business.
And what about from the woman's perspective? I mean, why does she put up with all this?
Well,
why doesn't she walk away? Because she's vulnerable. She sees herself as being under his control.
Well, I accept that, but and the judge accepted that. But that factor alone, the wrongful and unlawful assertion of authority, isn't enough to establish vicarious liability. But the judge accepted that, and I accept that, obviously. I mean, he is obviously endowed with a huge amount of power, and he abuses that power. And one of the core reasons she sticks with him, also because he threatens her and says he knows someone called Death and all this sort of stuff. She's personally scared of him as well, and the judge finds that as a fact. But yes, because he's got all this power, and she's got precarious immigration status, and we know from the interviews later that she'd lied about the marriage and all the rest of it. So obviously she's in a vulnerable position, of course. And he abuses that, no doubt about that. But that's not enough. I'll return to the judge's judgment, but the real point I'm just trying to drive home at the moment is this point about the authorised acts and unauthorised acts, because it really is important in our submission not to too broadly define the authorised acts, because the whole point of that test is to juxtapose the non-authorised acts, to compare those with the authorised, to see if there is a sufficient link to say that there's a course of conduct. And that in my submission, I mean, I'll be told if I'm wrong, but my reading of the Morrison's case is exactly that. No, you can't say that the authorised acts is to deal with the data. Just like in this case, you can't say that Mr Bastian was authorised to investigate potential infractions of the Immigration Act. Oh, well, he was broadly entitled to take her around in his custody. No, he was specifically and narrowly authorised to take her to check her address. And the judge finds as a fact that he then exhausted those duties, but nonetheless, for his own personal gain, on a frolic of his own, decided to continue the detention. But that Mrs Bethel also must have occurred to her that he was no longer on immigration business. I mean, she finds that as a fact.
I'm not sure ultimately where this gets you, because we might agree that you can define authorised acts in a pretty narrow way. Yes. But our question in deciding vicarious liability is surely to decide whether there's a sufficient connection with the authorised acts.
Yes. Oh, yes.
So it's all the other factors. You say, oh, well, you've got to put the other factors in place.
Yes.
But, you know, the fact that objectively it appeared that he was exercising control and Mrs Bethel thought that he was exercising control, he objectively appeared to be continuing to detain her in an exercise of apparent authority. These are the factors surely we're going to have to look at, rather than, in a sense, quibbling about how precisely you decide
Yes.
the authorised acts. Although I agree with you,
Right.
in the course of employment, we have to decide what the core of the course of employment is.
Yes.
We have to decide what the core of the authorised acts are.
Yes, well, thank you very much for that indication. I mean, I don't think I was embarking upon an academic exercise. It's part of my argument that I'm going to come to now, that the trial judge understood the importance of making that distinction between the authorised and unauthorised acts, and it's the bedrock of her judgment. So can I now just sort of make good that point by turning to the judge's findings? So it's tab 13. And this, by the way, my Lord Burrows, is trying to answer your Lordship's question. I'm not skirting over it. I'm trying to engage with it. Can I just turn up, please, paragraphs 12 to 15, first of all, on page 16, page 16?
Page 16.
16, please, yes. Just to make the point at paragraph 13 of the need for a female officer to be present during the interviews of female detainees, that's the protocol that's in place. After the interview,
Do we see mention of the protocol somewhere in the judgment?
I'm sorry?
Do we see mention of the protocol somewhere?
Yes, yes, or breach of it, you do, yes. But at the moment, the judge is just here summarising the facts as she finds them. After the interview, Mr Bastian called the Assistant Director of Immigration to check out the information given during the interview as to her address. He told Benaby that a female would be accompanying him, and there's an important finding here that he deceived Mr Benaby by not informing him that the female was a friend, not an employee. Nonetheless, he was given permission to effect the inquiry. And the finding in paragraph 15 that she was released into his custody to verify her correct address. So that's the scope of the authorised acts, although even the authorised act is to some extent, perhaps I use the word tainted rather than vitiated, but tainted by the fact that he breached the protocol by deceiving the immigration authorities, just as the officer breached the direction not to take the revolver out of the police station. So it's a factor, we say, a factor, only a factor, but a factor that the judge was entitled to take into account in the scales against the close connection. We'll come to that in a moment. Paragraph 20. Sorry, I think we can.
Can you help us as to what the effect is of her being released into his custody?
In law? Or,
yes.
Well, in law, she should have been released pursuant to a custodial order but that wasn't done. So a release order was made. So legally, she was released. So legally, I think the judge accepts this. She says that there was no legal basis for her continued custody by Mr Bastian. There was a release order. So she could, in theory, in law.
When a person's in custody, normally they're detained.
She was detained in the detention centre, and then a release order was made under the immigration regulations whereby she was released. So she was legally free to go, and Mr Benaby accepted that.
But I think the order specifies that the release is into his custody.
Yes, that's not how it should have been done. I mean, she was technically free to go, but the point is we obviously accept for the purposes of this appeal and the close connection test that in reality, she was in the legal custody of Mr Bastian in his capacity as an immigration officer.
And that means that he was authorised to detain her, presumably.
Well, it was authorised to take her to verify her address, yes.
The suggestion made by Mr Bennaby when he said with hindsight,
Yeah.
I forget the precise wording, she should have been subject to
Custodial.
a custodial order. So if things had been done properly, she would have still been in custody.
Yes, it wouldn't have made, yes, exactly, it wouldn't have made any difference. It would have still behoven him to just do what he needed to do, then return her, or let her go. I mean, I think the idea was that he would check out her address and see if Mr Bethel's really there, and then let her go.
It might be thought quite important that someone who has been detained knows whether they are in custody or not. And clearly the release order is ambiguous.
I think it was clear to her that she was not free to go. I accept that.
And if the procedure had been followed properly, that is the effect.
Yes.
Yes.
So if the correct legal machinery had been deployed, she would not have been free to go, and de facto she wasn't free to go. And therefore I accept that, you know, for the purposes of, I don't want to get lost in the nuances of the legal technicalities, this is a close connection test. For the purposes of the close connection test, I accept that one of the authorised acts, tainted though it was by his deception, which is not irrelevant, one of the authorised acts was to take her in his capacity as an immigration officer and check the address, yes. But then he should have let her go.
So she was released into his custody, albeit,
Those are
you
the
say,
words used.
albeit you say de facto, but for the purposes of the analysis which we have to carry out.
It was an authorised. She wasn't free to go.
No, she's
He
a prisoner.
wasn't free to go. And I accept that. I mean, I accept that the detention didn't come to an end. I mean,
So she was as much in custody as somebody being taken from Pentonville prison to the Old Bailey in a prison van.
well, I'm not sure whether analogies with criminal prisoners. I don't know. He was in administrative custody of.
But even in this country as well, immigration officers have powers of detention.
Yes.
And somebody who's detained by an immigration officer is that person's prisoner, I would have thought.
I think I'm prepared to accept
Because they're lawfully detained.
Yeah. It just wasn't legally done in the right way, is all I'm saying. And therefore, technically speaking, I think the judge says maybe there was a debate about whether in fact she could have gone. But who cares? Because I accept that she thought she was forced to stay with him, and she was right in effect about that at that stage. So the authorised act, on the authorised acts side of the scales, I do accept that he was authorised to take her out of the detention centre and check her address, at least. Arguably, I mean, I don't think she'd already been interviewed, and the interview had resulted in a release order. I mean, there's no purpose for any further interview, but anyway, that's what he did after hours when the immigration centre was closed. I mean, but certainly he was authorised to do the initial verification check. I accept that. But all the rest of it, stopping off, you need to collect gas and get a bottle of wine, going to Starbucks, you know, and so on and so forth, Chinese liquor store and all the rest of it, no. Can I just turn to please paragraphs 100 to 102 of the judge's judgment. This is at page 33 of the bundle, 33. Here the judge is setting out the evidence in very, very summary form of Mr Bennaby. And he confirms in paragraph 100 the conflicting information about her address necessary to attain what her correct address was. And therefore he gave Mr Bastian permission to lawfully conduct his inquiries. And this is where the judge says it's unclear whether Mrs Bethel was free to go. He said she was released to Mr Bastian, but if she objected, they would have allowed her to go. However, he could not say whether she was told. Anyway, we've been through this, and I've made the concessions that I think are appropriate on the evidence. And then he makes the judge summarises the point about the custodial order in paragraph 102. Can I just then look at paragraph 110 onwards of the judge's findings in respect of the rape and sexual assault and detention. Paragraphs 110 to 114. And then I must rightly emphasise the point in 114. The judge says, finds that Mrs Bethel did not run away because she was afraid, not just of the immigration authorities, but generally, but Mr Bastian in particular. And you will have seen, I think, references to things he was saying about having a licensed firearm and knowing someone he called Death and those sort of things. And she was vulnerable and helpless in the context of a man who was endowed with a lot of power.
And when she says endowed with a lot of power, she means by the state, doesn't she?
I think that is a fair reading, although I would also emphasise that I do think the judge is saying also that Mr Bastian is personally frightening her as well. But yes.
Yes, I was just focusing on endowed with. I mean, he may have had personal power, but what she's talking about is
what she's talking about is
that power rested in him and came from the state.
Yes. Here is a vulnerable person with precarious immigration status who is being abused by a person who misusing their state powers. No doubt about that.
And, I mean, the previous sentence makes it clear that she's concerned about the power that the immigration authorities generally have over her. And Mr Bastian is the personal representative of them on the ground, dealing with her at the time.
And in the context of the unlawful detention claim, the unlawful detention claim in respect of the period of Mr Bastian's property is made out because she's afraid to leave because of the immigration, his parents. I accept that, and there's no getting away from that. But we say that that's not enough on its own when one looks at the other factors that the judge bears in mind. So can I just emphasise for the purposes of the judgment, the point is repeated. It's not a point that helps me, but I want to be honest and open about the way I present the appeal. There's no getting away from it. There's another finding at 150, paragraph 150, which is on page 45 of the electronic bundle, in the context of the unlawful imprisonment claim against Mr Bastian. And even more clear at paragraph 151 is the judge's findings in that regard.
150, she's just setting out the law.
Yes, and then 151, as I say, is where the point is made even clearer still.
The judge's finding was that there was unlawful imprisonment for which the state were responsible up to the point Mr Bastian took her out, but that no vicarious liability after that.
Yeah, I think technically speaking, it should be after he'd conducted his inquiries at the address. So there's probably a technical point there. But yes, the point we're concerned about is the unlawful detention and rape at the property. That's the point. I mean, if there's another hour or two after she was released, I don't think anyone will quibble about that. But it's what happened later that's the problem.
Although that might show the judge's thinking that she hasn't considered those points.
Well, I think it's clear that she has, to come to that.
But it's clear enough at the end of 151, isn't it, that she regarded the whole of Mrs Bethel's time with Mr Bastian as a time when he was imprisoning her.
Yes, well, I think to be fair, my lord, there was a lot of issues in this case, and the periods were divided up in the most sensible way in which it could be divided up. I'm not sure.
Well, otherwise, why is she entitled to damages for the whole of that period for false imprisonment? She's very clear and precise about that.
Well, Mrs Bethel was unlawfully detained at the immigration centre. So it follows that for the period of continuing custody in his capacity as immigration officer, the state would also be liable because there's just no basis for a detention in the first place, let alone the extra bit. Maybe I've misunderstood the question, but certainly, whether the first couple of hours or the first hour is unlawful detention by Mr Bastian in his capacity as an immigration officer, for which technically speaking there should be vicariously liable, and then after that, that's just not the detail that the judge went into.
No, but it rather shows that she wasn't necessarily thinking about the fact that she was still in custody at that point.
I think she does know that. I'll come to the findings that the judge makes. It's quite clear that the judge does make a distinction between the things that he was authorised to do and not authorised.
But Mr Pennington, can I just press you on this?
Yes.
She says he was Mrs Bethel was falsely imprisoned by Mr Bastian for 22.35 hours. She's therefore entitled to damages for false imprisonment. Isn't she saying against the state as well? In other words, that the state is liable for the false imprisonment, whether or not it's liable for the rape?
No.
Maybe I've misunderstood what she's saying.
I think the judge... No, the judge is saying that the unlawful detention by Mr Bastian, from the moment he takes her out, actually, but I accept it should technically be from the moment he probably exhausts his immigration duties. But that depends on the view you take about the fact that he took her out.
What was the extent of this, under the judge's order, what was the temporal extent of the false imprisonment liability of the state?
It ended when she came out of the...
Yeah, so it covered the whole of the period when she was with Mr Bastian.
No.
Oh, didn't it?
No.
Oh, it ended when he took her out?
Yes.
I see, okay.
Yes. The judge says at that point you deceptively sneaked her out without proper protocols.
Thank you.
You took her on a whistle-stop tour of all of these things, and therefore all of that is just him on the...
Okay.
That's what the judge said.
Okay, so she doesn't there mean against all the defendants?
No.
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 And you're going to come to the analysis where she deals with that point about her being in custody.
Yes, so can I just...
Well, just before we leave 150 and 151, I mean, the judge is putting it all in terms of Mr Bastian's use of the authority which he's been clothed with by state officials. We see 150, second sentence, the use of authority is enough. So she's putting the whole of the false imprisonment claim on the basis of him using his authority.
Yes.
And in 151, she makes a finding that Mr Bastian misused and abused his authority as a senior immigration officer to make Mrs Bethel believe that she had no choice to go with him.
Yes.
So that's the instrumentality that he has used to keep her under his control is the authority he's been clothed with by officers at the station giving him this power.
Well, he has the authority that he has as an immigration officer that he then misuses by falsely, giving her the impression. But yes, he's misusing his authority in order to persuade her against her will to stay. That's right. But that doesn't answer whether that unlawful misuse of authority is so closely connected to the tasks that he was authorised to do that it's fair and just. And that fact alone can't be enough. Otherwise, every time somebody misuses their authority to commit a tort, their ipso facto employer is held vicariously liable. I don't think nobody's denying this connecting factor, and nobody's denying the strength of it, but it's not enough.
Yes, thank you.
Otherwise, vicarious liability would just flow in almost every case. And can I just please turn to paragraphs 1... where am I? Yes, well, just briefly, just 161, where the judge goes through the law. The Court of Appeal accepts that the judge correctly directed herself on the law. The judge relies on the judgment in the Bernard case, summarises the legal position in Lister. And at the bottom of page 48, the intense focus required on the closeness of the connection between the tort and the individual tortfeasor's employment. And then at the bottom of page 49, the best answer, perhaps, is that the wrongful conduct must be so closely connected with the acts of the partner employer is authorised to do, and so on. We know that's the test. And then the judge talks at paragraph 162 about the issue of risk. So she's plainly well aware, cognizant of this point about risk and power. Then the judge summarises the case of Hartwell, where the officer was held to be on a frolic of his own, having deliberately and consciously abandoned his post and duties. And then on paragraph 65, still in the Hartwell case, 165, still in the Hartwell case, I'll just pick it up in the second paragraph, the second half of that paragraph, beginning the connecting factors relied upon as satisfying this test are that Laurent was a police constable on duty at the time of the shooting, that his jurisdiction extended to Virgin Gorda, and that before leaving Jost van Dyke, he'd improperly helped himself to the police revolver. So those were the factors that were relied upon in support of the vicarious liability finding. Those factors were held in paragraph 17 by Lord Nichols in the Hartwell case, all to fall short of satisfying the applicable test. From first to last, from deciding to leave the island of Jost van Dyke to use firearm in the bar, his activities were nothing whatever to do with any police duties, either actually or ostensibly. I accept that. There's obviously a distinction. I mean, every case is different. He had no duties beyond the island of Jost van Dyke. He put aside his role as a police constable, armed with the police revolver he'd improperly taken, and embarked on a personal vendetta of his own. Now, that case I accept. The facts probably are quite clear. I don't think that it was a case that was borderline. But it is important, nonetheless, to note that his lordship does consider the improper use of the revolver as a factor that points away from a close connection, which does support my submission that the authorised acts need to be narrowly defined and everything else put on the other side of the scales. And then the judge picks up the theme at paragraph 166 of the judgment, personal venture, frolic of his own, and the idea that was discussed in the Morrison's case. I think I can, I don't need to go through the discussion that follows. I think we can pick it up at 178, paragraph 178, which is on page 55, where the judge sets out the test as summarised by Lord Toulson in Mohammed. What was the nature of his job? In other words, what are his authorised activities, as we prefer to say, I think now? What was his authorised acts? And then was there sufficient connection between those and the tort? On paragraph 171.
171.
179, I apologise, 179. Each case will turn on its own peculiar facts and circumstances. It was within Mr Bastian's remit to interview Mrs Bethel and then to verify her correct address. As I understand it, part of his due diligence was to verify whether she was living with her husband effectively. However, Mr Bastian knew well that in doing so he ought to take along a female officer. He lied to Mr Beneby. I've already taken the board to the earlier finding of fact point about the deception. And it's under those circumstances that Mr Beneby released Mrs Bethel into his custody. So in my submission, what the judge is doing here is carefully and narrowly as she should, determining the authorised acts, but noting as she does that even those authorised acts are tainted by the fact of this deception. And it's only actually in those circumstances, because of that deception, that she was released into his custody at all. So the opportunity to commit the tort, we say, was materially brought about by Mr Bastian's breach of the protocol. And we say that's not something that can be bundled into the authorised acts. It's quite properly something that sits on the other side of the fence, as does taking the revolver in breach of the direction, as an example. And the judge is therefore right to concentrate on that point.
Sorry to go on about the protocol, but it might be relevant if we're looking at the fault-based element that you dealt with at the beginning. Is this
is it.
What you say is the protocol? There's no actual mention of a protocol.
It's not written down, so I think the evidence of Mr Bennaby it wasn't written down, but that was, everybody accepted that was the deal. And certainly there was a female officer, Atilda Bowles, that was present at the interview. Sorry? Thea Moss, sorry, apologies, Thea Moss.
Yes.
My fault. Atilda Moss was at the station. Atilda was at the station, yeah, right, sorry. What was I talking about? Yes, so Bennaby's evidence it was not written down, but that was the accepted protocol. And the judge finds that Mr Bastian was well aware of it and deliberately breached it. And it's in those circumstances, and only in those circumstances, that she actually came to be released into his custody in the first place. And then at 181, although Mrs Bethel may not have been aware of the exact limits of Mr Bastian's responsibility, it must have been clear to her during his 8 stops, especially to the Chinese liquor store, that she that was not within the remit of verifying her correct address. So what the judge is doing here, we submit, is the correct approach. It's an exacting analysis of what were the authorised acts, and noting that in fact he wasn't authorised to take her out on his own, any more than Mr Skelton was authorised to send the data to the newspapers rather than to KPMG. We need to be a bit more rigorous and disciplined about what the actual authorisation was. Now, I have accepted, because I don't want to get lost in a debate about whether his breach was so serious as to vitiate the authority. I don't want to get lost in all that. So I've accepted that there was, in a broad sense, or in some sense, authority to verify the address. But it's not irrelevant to note that even that was something that was done in breach of the protocol. And it's difficult not to see that really as the prelude to what follows. Why is he sneaking around on his own? And that Mrs Bethel herself must have realised, okay, he's got all this power and I'm scared of him, but actually I know he's not at this stage doing what he's authorised to do. That's finished, that's come to an end. And that's made more...
She stops short, doesn't she, of saying that Mrs Bethel didn't think she was any longer in his custody, albeit that he was apparently doing all sorts of things which weren't part of his job while she was in his custody.
She doesn't go beyond the finding that...
Yes, I mean, she simply says those things weren't part of his job.
Yes, but I think the inference is that, yes, once you get back to the house and he's trying to ply you with wine and food, and that's the period that we're really concerned with.
Yeah.
I mean, that's obviously when everything goes haywire, and we say, well, those extreme and unusual events, even Mrs Bastian must have seen... Mrs Bethel must have understood herself that when they're going on this whistle-stop tour of KFC and all these other places, that there's no sensible sense in which she's engaging anything to do with immigration. She's still scared of him, I accept that, and he's still misusing his power to keep her, but it's got nothing to do with what he was authorised to do. It's nothing to do with the authorised acts. And that's the point that the judge is really making here, is listen, this hasn't got anything to do with what you were authorised to do. And even what you were authorised to do, you procured that authorisation by deception. And that's why the judge then concludes in our submission in 182, cannot be said that taking Mrs Bethel to his home and sexually assaulting her was in the course of his employment or sufficiently close, in other words, not closely connected, to make it right and just for the immigration authorities to be held liable. Shortly put, Mr Bastian was on a frolic of his own when he took Mrs Bethel to his home, having deliberately and consciously abandoned his post and duties. He had no duties beyond investigating the correct address and was fully aware that a female officer ought to be with him. So the judge is saying there, okay, authorised acts here, actually they're very narrow, and even those were procured by deception. And on the other side of the scales, as factors that pull away against a close connection and point towards a personal frolic of his own, is that he exhausted his duties, he's acting beyond authority, he's entirely put aside his role as an immigration officer and is truly and properly speaking embarking on a frolic of his own. So although the judge stops the damages clock at the moment Mrs Bethel is taken out of detention, in reality, the real point that we're all focusing on is this point. This is what the judge is really focusing on. Look, that part of what went on can't sensibly be said to be something done in the course of his employment.
It might be said, it doesn't seem in paragraph 182 that the judge has factored in her earlier finding at paragraph 151 that the way in which Mr Bastian induced Miss Bethel to believe that she had no choice but to go with him was because he was abusing his authority as a senior immigration officer.
Yes. She doesn't expressly say that, but she does make two separate, very strong findings on that point. And the whole underpinning of the unlawful detention case against Mr Bastian is premised on that. So we say it's obvious that the judge has that in mind, but nonetheless, actually, that's not enough. And all these other factors point away from it. He sneaks her out in breach of the protocol, takes her on a whistle-stop tour of all these things, and then much later on in the evening, detains her in his property and rapes her. And the only connecting factor, in truth, the only connecting factor is that he's an immigration officer and that he's misusing his power. That's it. Actually isn't anything else. What else is there?
Well, I think we said against you that the connecting factor is that she remained until returned to the detention centre or released in his custody, a custody which had been conferred on him by the state, by his superior, albeit that he committed a deception in setting that custody up, and that she didn't cease to be in his custody until he returned to the next day.
Well, I think because the Court of Appeal said something similar, I need to address this point about custody. There's custody in his capacity as an immigration officer, and that custody, that authorised act, as the judge said, effectively, he'd exhausted those duties. The custody at that point is in his own personal capacity.
Is that right? If somebody is released into my custody for the purpose of enabling me to carry out a specific task, and I carry that out with that person in my custody an hour later, I don't suddenly become free of any duties in relation to the custody of that person. I've either got to return them to where they came from, or release them, if I have power to release them.
But if you don't release them, you're then in breach of your duty. That's fine. But for the period that continues, you're then just detaining someone in your presence.
I'm just looking at the judge saying that he had no duties beyond investigating her correct address. I can understand what she means in the sense that was the purpose of her being released into his custody. Yes. But not that he had no duties in relation to it once that purpose was carried out.
I think what the judge is saying is, because she's applying the unauthorised acts test, the close connection test, she's saying his authorised act came to an end because he had no further immigration duties and therefore no authorised basis to continue the detention. He should have released her. He was in breach of duty for not doing it. If your lordship likes it, I don't think it makes respectfully any difference to the analysis. He's in breach of duty, whatever. But the point is that from that point onwards, he is on a frolic of his own, and he is personally detaining her, because otherwise no question of vicarious liability even arises. I mean, if it's right that she is in immigration custody overnight, then we don't need to even ask the vicarious liability question, do we? I mean, it's just a continuation of state custody. The whole point of the vicarious liability question being asked is that he's detaining her in his personal capacity, and the question is whether nonetheless his personal detention of her and rape of her is so closely connected to the thing that he was authorised to do, which was to detain her for a small period of time to check her address, that the state should be held liable. I mean, if the conclusion is, well, she's been in immigration custody overnight, well, that's the end of it. There's no vicarious liability question.
Even as far as the rapes are concerned?
Well, that's done while she's in institutional custody. Pretty difficult to get out of that, isn't it? I mean, she's actually
if she was, as you say, in the custody of the immigration
in his capacity as an immigration officer. Yes, in other words, if the only difference between the period of time she spent in the immigration centre and the period of time she spent in his house is that it was just a different building, it'll be pretty difficult to shake off vicarious liability for a rape that took place within an institution. I mean, I'm not going to bind myself to that point forevermore, because no doubt there are other difficult cases where difficult facts need to be pretty difficult, wouldn't it, if it took place in an institutional setting or one that was effectively an institutional setting. The whole point of the question that's being asked in this case is, when he goes against his authority, takes her to his home, she's got nothing to do with any of the immigration officers, finding a fact by the court, is that period of personal detention and sexual assault so closely connected to what he was authorised to do that nonetheless the state should be held liable for those extreme and unpredictable events? And we say no, and the judge was perfectly entitled, for the reasons she gave, to reject vicarious liability. And I do emphasise at this point, the point I made at the outset, which was where a judge in a difficult area like this properly directs herself on the law, makes a series of unimpeachable findings of fact, applies, as this judge has, carefully, and I say accurately, the close connection test by narrowly and carefully defining the authorised acts and then sticking everything else on the other side of the scales and going through the process of reasoning. That judgment should not be disturbed. Even if some people think I might have gone the other way. There's nothing wrong. That's the central. There's nothing wrong with the judge's judgment. That's the central submission. Can I now just turn to, please, the Court of Appeals judgment. The only substantive judgment was given by His Lordship Sir Michael Barnett. The vicarious liability assessment starts at paragraph 217, which is at page 132 of the electronic bundle. Yeah. Thank you. Thank you very much. Yes, good point. Yes, quite. We can turn, I think, to the Justice of Appeal sets out the findings of fact, or some of them. We can skip forward, therefore, I think, to perhaps to two. Just check. I think we can skip through to 223, paragraph 223, which is on page 137. My learned friend reminds me there that the trial judge, the finding of Sir Michael was that the trial judge's statement of the law is correct. Therefore, she is accepted that she correctly directed herself on the law, and that's evident in any event from the judgment. Can I just pick up, please, at paragraph 228, page 142. There, the judge cites the N case. And large extracts of that are then copied into the judgment. At paragraph 229 on the next page. This is about an off-duty policeman sitting in his private vehicle who spots somebody drunk, basically, coming out of a nightclub, offers to assist, and then later rapes her. Page 114, paragraph 32 of the end judgment. The judge was satisfied in that case that the officer was effectively on the prowl with the intention of finding a vulnerable woman. In these circumstances, he did not, as it was put himself on duty. The police do not owe a duty of care to accord a potential victim of crime appropriate support, and the reference is Brooks. I'll just explain, I'm sure this is apparent anyway, but the police are in a unique position because they can bring themselves on duty.
I wonder if that case would necessarily be decided the same way today. You think about a case like Sarah Everard, where the policeman uses his warrant card to detain a woman and then attacks her.
Yes, I think the difference there is that because police officers can self-authorise, so unlike the position of an employee like Mr Bethel, who has to go to his superior for directions on various different things, it was always accepted that he was an employee in this case. I appreciate you could have had an argument about that, but we didn't. Whereas an officer here can certainly in England and Wales, can self-authorise. So if they're off duty and they see a circumstance that if they were on duty would be something that would engage their responsibilities, they can come on duty. So by flashing a warrant card and arresting somebody, she was arrested by the state. That's the difference. Whereas in this case, the judge is saying, well, actually, the police don't owe any duties to her to assist her, and therefore he wasn't putting himself on duty.
He was wearing his uniform.
Yes, but he wasn't putting himself on duty. This is really important because it's the unauthorised acts and the authorised acts. Because he was off duty, he wasn't authorised to be in that area, and he had no duties as a policeman. So his only act was to embark upon a situation in which he had no business and to misuse his status as a policeman in order to get her to go with him. But all of that's on the unauthorised side of the scales. So I say that this case would be decided actually on a proper analysis in precisely the same way, because there's an important distinction between an officer who uses a warrant card and then in fact does bring themselves on duty, because that then becomes part of their authorised act. They are authorised to do that. It's authorised. And one of the points in the shooting case, in the Bernard case, was that it was accepted by the police in that case that actually if an officer did need to use the phone, even if he was off duty for some relevant point of view, he could go to the front of the queue and demand. That's the sort of thing he could do. So again, each case has to be looked at on the facts, but it's really important to do what the judge did and to really be close analysis on the authorised acts, and then everything else goes on the other side. Because those small differences can make a difference to the outcome. And then the judge makes the point there in paragraph 35, unlike the warden in Lister, he did not have any specific duty of care for the claimant, nor was he purporting to perform a police function such as arrest? Nor, of course, he would have been able to arrest her if he had have flashed his warrant card and committed. That's the difference with police officers. But in any event, I just make that point because there's no suggestion, although Mr Bastian has powers of arrest and powers of investigation, there's no suggestion that he can jump on and off duty and self-authorise. In other words, one doesn't look to what Mr Bastian says about his powers in order to delineate what his actual powers are. Whereas in some of the police cases you do that, because if a policeman says, "Hi, I'm on duty," he is. I think, going on my time, I better skip to, the judge also refers to a South African case, which has a number of very different features to it, including the fact that the victim was in the police car at the time and so on, and then a very short extract from a case from California, which, again, I'm not sure takes the matter that much further, but we get to the meat of Sir Michael's judgment in paragraph 238, which is on page 153 of the bundle. So can I just take this one step at a time? Paragraph 238. Firstly, Sir Michael says, at all times, Bastian had custody of Bethel in his capacity as an immigration officer. Just pausing there. Respectfully, that is not the question. I mean, it's not right. Because if it was right, then we wouldn't need to have a discussion about vicarious liability. It wouldn't arise for the reasons I've already given. And it ignores the careful findings by the judge about the true nature and extent of Mr Bastian's actual authority and what he did extraneous to that. But of course, if you start from the erroneous position that she's in his capacity as an immigration officer, then, I mean, if vicarious liability follows, I mean, the whole question is, because she's not in his detention, because he's not authorised to detain her in his capacity as an immigration officer, nonetheless, is his detention of her in his personal capacity, but claiming to be using his or misusing his powers as an immigration officer enough to bring it within the scope of employment. But that statement betrays respectfully a fundamental misunderstanding of the law of vicarious liability and a misunderstanding of what the judge has already found. And that misunderstanding respectfully continues in the next paragraph. The judge says, Mr Bastian, having obtained her from the detention centre, was doing duties as an immigration officer, and makes the point, which we accept obviously, that she was taken to her home and then to the offices. He did not release her. She was not free to go, etc. Well, I understand all of that, but that's not the question. The question is, having delineated the authorised acts, what point did his immigration duties come to an end? Well, the judge has made findings on that, they're just ignored. And then did everything else that followed, was everything else that followed a frolic of his own, or are there sufficient connecting factors to bring it within the scope of his employment? So again, the judge just respectfully just doesn't engage with the actual law of vicarious liability. Then it's said, lines down. And this, I think, is really the clinch point for Sir Michael. The following morning, after the rapes, Mr Bastian took her to the police station.
It should be he told, I think.
Sorry, I'm sorry?
I think her should, I think, be he, or were he.
He, yes.
Yeah.
He, yes, sorry, it should be, apologise.
So there's an errant R.
It was driving me off course, yes. He told Corporal Butler that Mrs Bethel was still in his custody, pausing there. This is inconsistent with him no longer having custody of Bethel or acting unconnected with his duties as an immigration officer. And just to, I'll make my submissions in that in a moment, but just to put that in proper context, can I ask the board please to turn the page and look at paragraph 241. Three lines from the bottom of the substantive paragraph. In this case, Bethel had been arrested in inverted commas. I don't know what that means. She did not regard herself as free to go. Well, we accept that. And then sets out the report of Butler, which supports the earlier point. And the passage that's underlined is, Mr Bastian stated that she is under arrest and was being held at the detention centre since Friday. And Sir Michael's view of this is, well, that confirms that he's acting in his duty as an immigration. Respectfully, it doesn't. That statement by Mr Bastian the next day adds nothing at all to the close connection test. The Court of Appeal here, in my submission, wrongly aligns the question of authorisation with the question of stated or claimed authority. The fact he claimed to the police that she was under arrest is neither here nor there. She wasn't under arrest. And the fact that he claimed she was doesn't make it so. It doesn't assist in any way, we say, with the close connection test. I'll just make 3 points. So, and all of these points are made in the context of the judge's proper application of, on the one side, the authorised acts, and on the other side, all the other stuff that's going on. So Mr Bastian's claim that she'd been under arrest with him, first of all, it's after the event. And we say, as a matter of principle, things that are said after a tort has already been commissioned are pretty difficult to consider as being relevant to the question of whether the tort was closely connected to the authorised acts of the employee. The tort's already been committed. What is actually going on here is just Mr Bastian saying something to evade detection. I accept that something that's said after the event could be relevant if, for example, it was the employer retroactively accepting or condoning the acts, for example, something like that. But simply Mr Bastian saying, after I've already committed the tort, oh yes, she's been under arrest, it just doesn't add anything to the equation at all. It's just a continuing example of him wrongly asserting his powers as an immigration officer. We've already got that. We've got that in spades. It doesn't add anything to the analysis.
The police officer didn't seem to find this surprising or do anything of that sort. So Mrs Bethel, not knowing that she wasn't still under arrest, apparently the police did.
Well, she would know she wasn't under arrest because she's never been, she was arrested originally, but there's no suggestion she was ever re-arrested. I mean,
But she was never released. At no point was she told she was released.
Well, she was made the subject of the release order, right? But yes.
The release order that said to his custody.
To his custody for the limited purposes, but yes, I accept. I mean, the judge has made findings about what Mrs Bethel did and didn't know, but I'm simply saying that after the event false assertion by the tortfeasor in order to cover their tracks or to detract attention from what they've done can hardly be something that makes all the difference in the analysis and justifies overturning the judge's finding that was based on an actual assessment of the tort and the circumstances leading up to it, and the connection between the tort and the circumstances leading up to it, and the authorised acts, saying after the event that he continues to wrongly assert facts in order to evade detection. So what? It doesn't.
Well, he's using, to be fair to the to Sir Michael Vaughan, he's using this quite long quote, if you like, to make good the finding of the judge that Mrs Bethel did not at any stage regard herself as free to go. That's he introduces it, so far as one can see, really for that purpose alone, rather than, as it were, hanging anything else on it. He's just saying all the evidence points to the judge's own conclusion that at no time did Mrs Bethel think she was otherwise than in his custody, i.e., did she think that she was free to go?
Well, if that's the only point he's making, then I can live with it, although it doesn't add anything. The reason my lord was already given. But I thought he was pleading that in aid of the proposition in the prior paragraph I'd taken the board to 239, where he says it's inconsistent. What he said to Butler is inconsistent with him acting unconnected with his duties. And all I'm saying is, just because he says he's under arrest falsely, it doesn't make it so, and it doesn't add a connection to his duties of the immigration. It doesn't add anything to the analysis. That's the point I make. But if all he's saying is, well, this shows that she wasn't free to, well, fine, I accept that.
I think you were critical of the Court of Appeal for not addressing what you described as the crucial question, when did his duties end? And you said that the judge made clear findings on that. I'm looking at the paragraphs 179 to 182. That's where you say she made the findings, is it?
Yes.
There's no findings elsewhere. I'm not.
Those are the meaty. Those are the ones that I've in my mind. Yes.
For my part, I'm not sure there's a clear factual finding as to when the duties ended.
Well, I certainly read the judge as saying, well, he'd exhausted his immigration duties once he'd done the verification address, which was the basis of the release in the first place, into his custody in the first place. That's how I read it. Everything else after that.
So after going to her home, effectively?
Yes. But, I mean, you could, I accept that it's probably a bit, you might be able to throw the Hawk Hill interview potentially in there as well. I mean, I wouldn't make that concession. It's not my primary case, but I can see that although the offices were closed, there was no need to interview her because she's already been interviewed. We say that's all just part of the ruse, but it's just part of a continuing example of him misusing his powers and trying to give her the impression that everything's hunky-dory so that she doesn't start phoning up her husband or phoning up Mr. Hanson, is it all right? But that's all part of the frolic, we say. And at no stage does the Court of Appeal descend to saying that the judge has done anything wrong, having accepted that she properly directed herself on the law. They then simply, in those short paragraphs, make several points that respectfully we submit either don't add anything or are just plain wrong, and then say, well, therefore the Court of Appeal takes a different view. We say, well, that's not, with the greatest respect, proper. There's no proper ground for overturning the judge's assessment, we say, which should stand. I don't know whether it's hot in here or I've just been under pressure, but I've drunk about 2 litres of water. But anyway. I don't have very long left.
Yes, and you haven't yet dealt with the first round of appeal.
I haven't dealt with the first round of appeal. We have filed a very detailed case on that point. I think I'm going to be forced to just rely on that in large part, but in the sort of 10 minutes or so that I have remaining, I think that clock may be deliberately set 6 minutes fast, I don't know, but
I think you've got a little over 20 minutes.
Oh, have we? Okay,
Yes.
how exciting, good. Right. Well, it's got a lot to cover, but I think the only way to do this, and I realise it's not a very elegant way of doing it, is just to rattle through and give all the references to the submissions that I would make in addition to what's already in the case. I appreciate that's not a very attractive way of doing it, but I can't at the moment think of a better way to get it done. So, with that said, let me embark on that task. So the first question is reasons for the arrest. What were the reasons for the arrest?
Yes, I mean, I think that's the point perhaps you should focus on, whether reasonable grounds for suspicion.
Reasonable grounds for suspicion. Well, let me just say what we say.
I think I interpreted you when you said reasons there, you mean reasons given for the arrest. But I think my lord is saying there's a stage before that, which is whether you had any reasonable grounds for suspicion in the first place.
Yes.
I mean, if it speeds you on your way, given that Mrs Bethel had produced a copy of the spousal permit,
Yes.
was it necessary to arrest her?
Yes. Let me.
Or was this just a roundup of Jamaicans in a nightclub late at night?
Understood.
And she gets swept up in a roundup.
I completely understand why the point is put to me in that way, and it's yeah. I think what I would say in broad terms is this: the evidence was that there was an intelligence briefing, and the intelligence was that there were illegal migrants, and that they were exotically dancing in G-strings and all that kind of stuff at a club in the middle of the night. So in other words, the intelligence briefing was legal migrants engaging in a black market economy in the middle of the night in a bar. Go investigate. And the O'Hare decision, Lord Hope's judgment, makes it clear that intelligence briefings certainly can form a proper part of the suspicion, because the investigation's at a nascent stage. It's just a suspicion. So then Mr. Superintendent Curry attends the bar, indeed finds a group of non-nationals, on his evidence, none of whom are able to produce any permit or evidence that they have immigration status. That evidence is at 1508. I don't have time to go through it, but that's the reference. Not aware that any of the Jamaican women produced a permit. So Mrs Bethel is also there. She also is unable to produce her permit, although she produces a copy. And the evidence of Mr Bennaby is that they don't issue copies. Mrs Bethel's evidence was that I can't remember whether it had a stamp on it or not. Thea Moss's evidence was...
Sorry, can you give us the page?
Yes, this is the problem. I get caught up.
So you said evidence of Bennaby, don't issue copies.
Right. So, paragraph 7 of the judgment, Mrs Bethel did not have the original. That's at 15 of the record. Paragraph 96 of the judgment at 33 of the record is the evidence of Thea Moss summarised by the judge. I would also invite the board to look at paragraphs 9 and 10 of Thea Moss's statement, which is at 404 of the bundle, in which she explained...
I'm sorry, so last sentence of paragraph 7, the finding, in fact, is the copy permit was issued by the Immigration Department.
I'd have to check if it was accepted that it was issued by the department. But Mr Bennaby's evidence...
Well, this is the finding, and the facts as I found them are as follows. Page 15, paragraph 7.
Yes. Let me just have a look. Yes, yes. So Mrs Bethel's, yeah, I think that's right. So Thea Moss's evidence, paragraphs 9 and 10, was that she interviewed Mrs Bethel, who told her she went to the immigration office and somebody from the office gave her a copy. But she didn't want to say more than that. She didn't want to get somebody in trouble. Sorry, that's how it transpired. And Benaby's evidence was, well, we don't issue copies. And then he says later in his cross-examination, well, copies aren't worth the paper they're written on. So that's a sort of background to all of this. Can I just give another reference for Thea Moss's evidence at 1601?
Sorry, what was the reference to what you just read out?
So Thea Moss's statement is at 404. It's paragraphs 9 and 10 of that. And then her live evidence at 1601.
Is this reflected in any finding of fact by the judge?
Well, the judge summarises the evidence of Thea Moss. It doesn't say that she disagrees with any part of it. And I can't see that paragraphs 9 and 10 of Thea Moss's statement are ever challenged. I mean, I think it's acceptable, or at least it wasn't challenged, that Mrs Bethel got a copy from the immigration office. She doesn't remember it had a stamp on it, but Mr Benaby's unchallenged evidence was, well, we don't respect copies because they're not worth the paper it's written on. That came out during the cross-examination.
And I think we're still waiting for the page reference for that.
Yeah, that's 1774 to 1776 in the transcript, and then paragraph 102 of the judge's judgment. So 1774 to 1776 in the transcript, paragraph 102 of the judgment, or paragraph 34. She doesn't make any specific finding, but again, it's not the evidence isn't challenged. And then I would just come to the judge's judgment now at paragraph 127, which is at page 40 of the bundle. Just bear in mind those points of context. The judge sets out the relevant part of the Immigration Act about necessary. I would just recommend that the board the decision of Hayes, Hayes, the decision of Hayes, an English decision on different provisions, but it sheds some light on what necessity really means, which doesn't mean do or die for a police officer. I mean, it just means, proper course of conduct is to arrest, to conduct an effective investigation. And then the judge says at paragraph 129, I therefore agree that the need to verify the immigration status was necessary to ensure that the Immigration Act is not undermined. So it's about effective and proper investigation. So it's context, really, and I accept that this is not a completely obvious case where you would necessarily arrest. But based on the information, based on what you saw at the bar, the judge, we say, was entitled, in that context where nobody else was able to produce a permit, there she is with only a copy, in the light of Benaby's evidence. I mean, the difficulty is a judge's statement of reasons is only ever so complete. She listened to all of this evidence over many, many days and will have understood, we say, the context of all of that evidence. And we say it's in that environment that the judge was entitled to hold at paragraph 132 of the judgment that there were reasonable grounds to suspect that the women were unlawfully in the jurisdiction, and that's what was meant by immigration purposes. They were being asked to produce their status, and then the finding, which must be part of her acceptance of Curry's evidence, the finding is that in the last sentence of 132, Mrs Bethel herself stated that she had a copy, but since it was only a copy, she was detained for verification. So we're in the middle of the night, the immigration authorities are closed, ID checks and outstanding warrants are being radio checked by the police, but nothing else. And it's in those circumstances, and bearing in mind that there is an unusual feature of there is an unusual feature of the offence of being without immigration status, which is it's committed by just being in the jurisdiction. Being within the islands without immigration status is the criminal offence. So if you release someone,
well, it may be, or it may be working depending on your immigration status. Presumably.
Yes, but if you do not have immigration status, I mean,
then
and
you shouldn't be there.
You shouldn't be there. So therefore, it's not like the police investigating a criminal offence that was alleged to take place 2 weeks ago. So in other words, they could say, well, I can come back to that later. I know where you live. I'm going to come to... The difficulty with an immigration offence, which is why the detention powers often follow, administrative detention often follows, is the fact that if you reasonably suspect somebody actually doesn't have a status to be there and you release them, the crime is there ongoing. Now, what the judge doesn't make any findings on...
Sorry, just before we move from 132, the judge is recording that Mrs Bethel gave evidence about this. Do we have the reference to Mrs Bethel's evidence? Can you help us with that? If you can't, just say so and we'll move on.
Can you get Mr.
No.
No, all right.
Sorry. All I would say is she gave live evidence, and that was the impression that the judge... My Lordship's not asking for a witness statement. You're asking, are you, for the precise basis for that finding, which I can't point to.
Yes.
Yes, I can't point to that. Sorry. Yeah. No, that's very helpful, Miss Jordan. Thank you. I was just right. Anyway, so I'm not really listening. The judge then goes on in paragraphs 133 to 134 of the judgment to say, well, once the position has been made clear at the police station, because further investigation into the immigration status has taken place, at that point she should have been released, and we accept all of that. But we do submit to the relatively low threshold of reasonable suspicion. The context and circumstances and the evidence that was before the judge does justify her finding that there was a reasonable suspicion that Mrs Bethel didn't in fact have valid immigration status, and that it was reasonably necessary to detain her for the ends of the Immigration Act in order to carry out a verification. That's a reasonable ground to arrest, we say. And the Court of Appeal's suggestion, or ruling, I should say, apologies, the Court of Appeal's ruling that somehow, in order to meet necessity, you have to sort of be no other way of going about it, we say is not supported by the authorities, in particular Hayes, and isn't consistent with the discretion that we would normally accord to police officers in the exercise of their investigative and arresting powers. It's not only where some alternative isn't open to the officer that they're allowed to arrest. It's broader than that. What I would also say, finally, although there are no specific findings on this by the judge, she does generally accept Superintendent Curry's evidence. And he did give quite a bit of evidence during cross-examination about the difficult conditions of the raid. And I just give some references there. So in the transcript, 1388 to 1389, 1394, that's talking the latter reference about checking identification and by radio checks back to the station. 1395 deals with checking for outstanding warrants. 1468, officers were seeking documents from the women as the judge held. And then at 1469 to 1470, the tenure of his evidence there is indeed, as found by the judge, that the reason for the arrest was verification. He talks about the safety of his officers, a baying crowd outside in a difficult area of the Bahamas, known to be dangerous to police. He only had 10-15 minutes to get everything done, wasn't able to complete the verification, so in the end, they were all arrested. And we say, respectfully, what's wrong with that? I mean, I appreciate it's not nice being arrested, but I mean, that is, there was a reasonable suspicion, it was difficult conditions, and the officers were perfectly entitled to come to the view that that was reasonably necessary, and the judge was entitled to make the findings that she did. The Court of Appeal's criticisms, we say, flow from a wrongful assumption or finding that a specific offence needs to be borne in mind. And the criticism of Superintendent Curry's evidence, in particular by Crane Scott JA, needs to be read in that context, because she's looking for something in his evidence that isn't there. It doesn't need to be there. And the Court of Appeal also, we say, arrived at an overly strict interpretation of necessary, which I think is the point I've already made.
What I'm puzzled about
Yes.
is it looks as if the evidence is to the effect that a copy of a spousal permit is a perfectly valid, legitimate document to prove your status. Otherwise, one would have a problem that wherever anybody lost the original, there would be a problem. But clearly the procedure seems to be, well, you get a copy. Well, that appears to be exactly what's happened here.
Well, my lord, I don't think there's any findings of fact on that, but I think Ben...
Well, they release... I mean, when you say no findings of fact, once it's been checked that that was issued by them, then there's no problem.
I think Ben...
So at that point, they're just saying, yes, we issued a copy, and, inferentially, a copy is as good as the original.
Well, I don't want to give evidence. I think all I would say is Benaby's position is we don't issue copies. She says, and she was cross-examined.
That's clearly, contrary to what the police have then done.
Well, Miss Thea Moss says that Mrs Bethel told her she managed to get a copy from someone at the immigration authorities, but she doesn't say who, because she doesn't want to get them in trouble. I mean, the underlying implication here is not meant to give out copies, but they did. She's got a copy. Does it have a stamp on it? Don't know. Benaby's position is don't issue copies, they're not worth the paper they're written on. Someone loses one, we go through an interrogative process and then we give them another one or don't give them one, that's that. but there's no clear findings on all this. Sure as day, she did get something from the immigration authorities, that much is true. But whether it was incumbent on the police to immediately and without more simply accept that, given the context in the Bahamas and the evidence of Mr Benaby, I would say no. I'm perfectly entitled to take the view, well, hang on a second. Let's verify that.
Thank you.
And that the verification was what made the arrest necessary. When one reads necessary as reasonably necessary in the rational view of an officer in the difficult conditions of a dawn raid with a baying crowd outside. That's how we put that. I think. Yes. Is there anything else I need to cover? I think I've given some references to the transcripts on Benaby's evidence, yes. Oh, can I just give some references, well, on whether, do I need to cover whether there were, what were the reasons for the arrest? I mean, the judge made a finding of fact on that, and we say that the Court of Appeal wasn't entitled just to substitute judgment on that point. But if I needed to, there are a lot of references within 3 days of cross-examination of Superintendent Curry that would rationally support the judge's finding that immigration status was the primary purpose of the arrest, which is the finding of fact that she made. And we say, primary finding of fact, Volpe applies. The Court of Appeal shouldn't simply have waded in and substituted judgment on that point. Right. Not without some sense of relief, unless there are any questions. I think
You've had more difficult mornings than this.
I have had more difficult mornings, but I think this one's particularly difficult intellectually rather than factually. And I find anyway. Well, I think vicarious liability is very, very difficult. I think that's evident from the many. I don't feel alone in finding it difficult, which is comforting.
Well, the sheer number of appeals is either the board or the Supreme Court has heard in the last few years on the topic suggests it's a widespread difficulty.
Suggests I'm in good company, yes, good. Thank you very much, my lord.
Thank you. Yes, Mr Smith.
Good morning, my lord. Good morning, my lady. So as between myself and Ms. Jordan, I intend to address the unlawful arrest issue, and then Ms. Jordan will address the vicarious liability. I have a few comments to make to give some context, as my friend has done, to what has happened, the context of this case. I'm grateful to my friend for having acknowledged the horrific rape of Mrs. Bethel by Mr. Bastian, but she was also, as found by the judge and the Court of Appeal, subjected to abuse of her constitutional rights by the state. And Mrs. Bethel was a courageous woman who sought to vindicate her rights, both as against the state and its agent, Mr. Bastian, who, by the way, was promoted during the course of the proceedings. Sadly, Mrs. Bethel passed away, and I wish to acknowledge her partner, Mr. Dominic Major, and her 4 children for continuing to pursue her rights. It is important for her family that her courage and perseverance in pursuing her rights should not be in vain. In order to leave a legacy to help protect others, as my Lord has said, there are so many of these cases that have come up, sadly, or it happens in the Bahamas a lot, but this is the first one that has been tried. To protect others from the kind of abuse that Mrs. Bethel suffered at the hands of the state. And as my friend has indicated, hopefully this will help to develop protocols and develop a precedent to prevent further abuse, both as to the power of arrest and also vicarious liability. The genesis of Mrs. Bethel's abuse is a continuing fundamental misconception that continues to pervade, despite case after case in the Bahamas, as to what the powers of the police and immigration are insofar as arrest of a non-citizen or what happens to a non-citizen once taken into immigration's custody. It is fundamentally that a person is presumed guilty until proven innocent simply because they are not a citizen or a permanent resident of the Bahamas. And I'll take your lordships to the relevant portions of the record to sustain that comment. And in arresting, they do not have to demonstrate any reasonable cause to suspect that an offense has been committed or that it is ever necessary to detain. They just simply detain. And once a non-Bahamian is apprehended, if there is no further police charge that is pursued, that person is then simply, and this was raised by your lordships earlier, what happened, it was a continuum. She remained arrested, and she was then processed by immigration. And the immigration department then simply acts as a sort of Spanish Inquisition or a star chamber, because often the person arrested claims to have status, as Mrs. Bethel did, and is simply ignored and held in detention, sometimes for 9 years. Lords, some of your lordships were in a case in the Nagumi matter, which I appeared on. And I'd like to invite your lordships, I'm not going to take you there, but I'd like your lordships to go to the Tamara Merson case, which was ultimately came before the Privy Council on issue of damages, but this was a case decided by Dame Joan Sawyer. She was a Supreme Court judge at the time in 1994. And the kind of abuse that your lordships will read in the Merson case continues. And what happened to Miss Merson, except the rape, is exactly the same as what continued to happen to Miss Bethel in this case. And I would just like to ask your lordships to go to paragraphs 108 to 112 of Merson, paragraph 127, then paragraph 140 to 142.
And we have some page numbers.
Those,
We have this-
it's in the new
case
bundle,
in an additional.
in the new bundle that was filed, and there are no EB numbers. It's C and AA tab, CAA 28 onwards, my lord. And that case deals, sorry, and the other page numbers are, my lord, 186, sorry, paragraph numbers 209 and 210, and there is one in particular that I can take your lordship to. It's at 215, which is exactly what happened in this case. At 215, which is at page C and AA 47, her ladyship indicates or finds that police cannot in normal times have powers to arrest and detain any person for any period while they look to see if there is any evidence that the person may have committed. The courts have to consider the position at the time of the arrest. And in this case, my lords, that is precisely what happened and what is pleaded by the defense, by the state in this case, is that they arrested, as they plead in a paragraph, I think 11 of their defense, that she was arrested in order to determine if an immigration arrest had been committed. And that, we simply say, is not permitted. Then I take your lordships very quickly on these general issues.
So are you able to help us with the page number for the defence?
For 215, my lord? Yes, that is...
Yes, 47.
Um, 215 is at page C and AA 47. 215 is in the middle.
Sorry, I was asking for paragraph 11 of the defence that you referred to.
What's paragraph for me?
Well, if it could be checked, you can give it to us.
I'll find it in a moment, Lord. It's at page...
19611.
My eyesight is leaving me. EB 196.
Thank you very much.
And paragraph 11. So, I'll turn first to the evidence of Miss Moss, who was the interrogating officer at the Immigration Department on Sunday morning. And I'd like to address a question put to my learned friend by my Lord Burroughs as to whether or not, on presentation of the copy of her spousal permit, whether or not she ought to have been released. And if your lordships go to page 167 of the record, electronic bundle, I take you to line 2 to 7. No, page 1607, where in a cross-examination, I say to Miss Moss, quote, if she had a copy of her permit, would she have been released? Answer, yes. Question, there would have been no reason to keep her. Answer, no. I think that's a complete answer to the question your lordship put to my friend. And then the other parts of Miss Moss's evidence, which I think are extremely important for your lordships to have in the back of your minds, are to be found at 1609, where Miss Moss again admits that when she remained in immigration custody. So at the time, this is line 7, at the time you conducted the interview, you didn't at that time have any reasonable cause to suspect that Mrs. Bethel had in fact committed an offense under the Immigration Act, did you? Answer, no. Question, so she was being interviewed for the purpose of determining what offense she might have committed? Yes. And then I would like your lordships to go to page 1611, line 9. And I ask, so is it your evidence that any person can be arrested by immigration, and if they can't prove evidence of some status, they can be detained by immigration until they prove their status? Yes, sir. That's the evidence of Ms. Moss. And then,
right, but I mean, Ms. Moss wasn't the arresting officer, was she?
it isn't, Lord, but I'm coming to the arresting officer.
Okay.
The point that I will make, good, is that the police would simply, they're not investigating. As Mr. Curry said, Inspector Curry said, we weren't investigating any immigration offenses. We simply turned her over to immigration. At many times in the cross-examination, I asked him what he was, after having arrested her, what his role was and what he did. And he simply said, I washed my hands clean of it, in essence, and I left Ms. Bethel to be dealt with by the immigration authorities. And then Mr. Benaby's evidence. Sorry. Yeah, on this issue of presumption of innocence, I take your lordships to page 1605 at line 18 to 20. Ms. Moss again, I question, so the burden is on the person to prove they are innocent? Yes. And then I take your lordships to Benaby's evidence very briefly on this pervasive approach that everybody is simply entitled to be arrested simply because they're not Bahamian. So at page 1774, Mr. Benaby is questioned, and he says, contrary to Moss, that because she only had a copy of her spousal permit, she was kept in custody. Yes. Had she had the original one, she have been kept in custody? No, she would not have been kept in custody. And then later, at page 1777, I question on this issue of simply being a non-Bahamian at lines 4 to 7. So as long as you reasonably suspect that they are non-Bahamian or permanent resident, yes, the law gives us authority to arrest this person. And I say...
I'm so sorry, which page are you on?
This is page 1777.
Thank you.
So I go on to paragraph 13, where he says, because the immigration officer doing the arrest reasonably supposes that the person is not a Bahamian or permanent resident. And I say, yes, and that authorized the officer to do what? To take that person into custody. Don't they have to suspect the person has committed an offense? And here's the kicker. Answer, the offense is that they do not have documentation to be in the Bahamas, or that they are not Bahamas lawfully. Then until we are able to verify that or say, yes, this person is lawful or not unlawful, and in the country lawfully or unlawfully.
Now, he's dealing, I think, with the powers of arrest of immigration officers. We're actually concerned, aren't we, with the powers of the police superintendent who arrested Mrs. Bethel.
The immigration and police officers are the same, my lord. I believe that's in section 10 of the Immigration Act. The only restriction is that they have a far less ability to arrest and detain because they have to have reasonable cause. to suspect an immigration offense, but then it must also be necessary to arrest them. And the construct of the Immigration Act is that where there are generally any issues, instead of arresting them, you then summon them and interrogate them. And there are penalties for not agreeing or coming for interrogation.
Yes. So the point you're making is that instead of, as far as the statute requires them to have a reasonable suspicion that an immigration offence has been committed, you say they're operating in reality, at least this gentleman was, on the basis that it's enough to have a reasonable suspicion that the person's not a Bahamian or
Correct.
a permanent resident.
And that is all Mr. Curry said in his evidence. In fact, he didn't hear even Miss Bastian, but Miss Bethel. His officers, I suppose, heard them speaking in a Jamaican accent.
Is there anything in the Immigration Act which requires a non-citizen to carry the permit with them at all times?
There's no, and we made that submission to the trial judge and to the Court of Appeal, and there's no such law in the Bahamas. Although, to answer you completely, I believe in the last few years, there was a law that was passed requiring persons to carry their driver's license with them instead of being able to produce it within 48 hours, which was the old process. So, turning now to the appeal against, appeal against the finding by the Court of Appeal that the arrest from 1 a.m. Saturday until 3:30 p.m. on Saturday was unlawful, as found by the Court of Appeal. I pause to ask, my lords, would you wish to hear Ms. Jordan first on the issue of vicarious liability, or do you want me to finish on the issue of unlawful arrest?
Oh, I think it'd be sensible for you to finish on this current topic. Yeah.
Sure. So, in short, it is our submission that the Court of Appeal was correct and that the state has not been able to show how the Court of Appeal misapplied the law as to the facts found by the judge. The Court of Appeal simply accepted and didn't seek to refine any facts. They accepted the facts found by the learned judge and applied, we say, the law correctly. The judge, as you'll note from her judgment, simply didn't deal with the issue of necessity at all. It was simply taken as a given that a person, once a foreigner, would be taken into custody for immigration purposes. And that is not an offense. Immigration purposes is not an offense. There was never a suggestion that it's 102. My lord. I see it's 102. I think we're supposed to finish at 1.
I think the clock's a little bit fast.
It's fast.
Okay.
You got another 5 minutes.
I was just given a note to hurry up. Thank you. So there is no offense of being arrested for immigration purposes or to be arrested to determine if a person has committed any offense under the Immigration Act. It simply just doesn't exist. And that is the basis found by the judge. She found at paragraph, is it page 132? Sorry, no, page 41, paragraph 132. This is Court of Appeal. I wish I could learn to use these computers like everybody else who's much younger than me does. With respect, the reason for the arrest, I accept Superintendent Curry's evidence that there were reasonable grounds to suspect that the women were unlawfully in the jurisdiction. Well, having produced and having found that she had a copy of her permit with her, which, as an agreed fact, was issued by the Immigration Department. I mean, it's it's perverse to maintain that there was reasonable cause to suspect that she was, even if that's an offense, that women were unlawfully in the jurisdiction, which in and of itself is not an offense. As my lord has pointed out, there are many other offenses under the Immigration Act, and in our statement of case, we set out I think there are 10 or 11 other offenses, or a list of offenses that a person can be charged with under the Immigration Act. But immigration purposes is not an offense, and being unlawfully in the jurisdiction is not an offense. An offense could be overstaying, an offense could be working without a permit. There are, as I say, a number of offenses, but not simply being unlawfully in the jurisdiction. And that's not what was found either. Mr. Curry said, you're being arrested for immigration purposes, not for any specific offense.
Sorry, could you just give me the reference for where you set out the different 10 or 11 offences, I think you said?
Yes. It's at page 2830, paragraph 50 of our case.
In the passage you just took us to, where the judge says that I accept Superintendent Curry's evidence that there were reasonable grounds to suspect that the women were unlawfully in the jurisdiction, was Superintendent Curry referring to Mrs Bethel? Or
So at the start of his cross-examination, my lord, I said, when you refer to women, do you always include Bethel in that reference? And he said, yes. I can find that for you as well.
And did he explain why he had reasonable grounds to suspect that she was unlawfully in the jurisdiction?
No. In fact, there is doubt as to whether he was in fact the arresting officer, because he said that he stayed away because he didn't want to be accused of doing anything wrong with the women. And so he stayed away, and his other officers conducted interviews, and each officer looked at their documents.
I think he says that he observed the documents being inspected by his officers.
Correct. Yes. And so he gave no reason for arresting Mrs. Claudia Bethel.
Well, insofar as the reason
women are
was
included.
the one that's in 132, he didn't explain what the grounds were for suspecting her.
No. No.
Now, I wonder if that's a convenient point.
It is.
Very well.
I'm trying to hurry so that Ms. Jordan can have more time on the vicarious liability point, which I think is far more important.
Fine. Well, I think we'll have plenty of time after a short adjournment. Now, there's another matter I need to deal with, Mr. Smith. You could just be seated for a moment. It's come to the court's attention that today is Mr. Almeida's last case in front of the board. John Almeida is a very old friend of the court. He's worked for Charles Russell for, I think, about half a century. And certainly he's been appearing before the board for as long as I can remember, and I'm sure a long time before that. It's not always appreciated how much any court depends on the litigation solicitors who appear in front of it for its smooth working. It all depends on the efficiency and cooperation, the attitude of the solicitors who work in the cases that come before the court. And John Almeida has been a very good friend to this court for many years. So we can't let this occasion pass without recognizing that and sending you our warmest wishes for every success in the next stage of your life. You'll be missed here, but you go with our very best wishes. We'll adjourn now and resume at 2 o'clock.
you.